Hi there. First, a disclaimer. This is not legal advice. I don't want you to sue me. It's just one musician talking to others about information I've picked up through the years that you might find interesting. In this episode, do I need to copyright my songs? The short answer is yes, and you can do it yourself. I have another episode that can help you with that, or you can have a service do it for you. The long answer is, it depends. So what is a copyright? It's the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record artistic works. Essentially, if you're the originator or assignee, it gives you the right to say how others can use your work. Here are some important dates using broad strokes to talk about copyright protection. Old works. In 2023, works published in 1927 expired, meaning their copyright expired and they entered the public domain. This means for 1927 and any prior years, you can publicly perform these works, record your own versions of them, and sell them. Many people just remember the year 1900. It's a nice round number and it's easy to remember. There are many great composers like Bach, Handel, Beethoven, Mozart, Tchaikovsky, and Vivaldi that created works prior to 1900. Even what some might call more modern classics like Rimsky-Korsakov are fair game. Rimsky-Korsakov died in 1908, which is a little after our easy to remember date, but maybe this example will help you remember. And of course, you can always look it up on the internet or hire an attorney. Here's an important facet of copyright law. If a public domain work, such as Beethoven's Fifth Symphony, is recorded by the New York Philharmonic and sold, it will not be in the public domain. While the underlying composition is in the public domain, the performance is not. As such, the performance will be afforded all modern-day copyright protection. Modern-day works, meaning anything from January 1st, 1978 and on, have a copyright date that lasts for the life of the author plus 70 years. If there are multiple authors, then it would be for the longest lived author plus 70 years. You can use the copyright symbol as soon as you affix your work in a tangible medium, such as a WAV file or an MP3. And to anyone to whom you provide your works, you should give notice that your work is copyrighted by attaching a copyright notice. These are the broad strokes, and for folks creating works now, it will serve them well. There are a few nuances not included in this episode, and if you want to know what they are, you can buy a book or talk to an attorney. Fair use. Folks love to use the term fair use, especially online. I'm educating people, so I can use it, right? Maybe. The thing about fair use is that it is a defense to copyright infringement. It's not an affirmative right, and fair use is decided on a case-by-case basis. Let's take a look at the elements of fair use. It allows you limited use without first obtaining permission. Some of the purposes include, but are not limited to, teaching, criticism, news reports, commentary, search engines, and parody. Consideration is given to the purpose and character of use. For example, did you make 10,000 copies of the latest blockbuster and sell them at the flea market? Or did you display a single frame from the movie to your cinematography students for an analysis of visual composition? Consideration is given to the amount used as a portion of the work as a whole. For example, did you copy a sentence from the book War and Peace and display it in class for your students to analyze? Or did you make 30 copies of Chapter 6 and distribute the copies to your students for them to write a homework assignment? The nature of the work is considered. By nature, I mean, is it a fictional novel, a biography, poetry, music, etc.? This can get complicated, but for us composer types, the important thing here is that courts are generally more protective of music films, and other creative arts, making a claim of fair use less likely to succeed. Also considered is the effect of the use of the work on the market or value of the copyright. Using my previous example of selling copies of the latest Hollywood blockbuster at the flea market, such sales would diminish the value of the copyright. The copyright holder has been denied revenue from the 10,000 copies of the movie you sold. On the other hand, displaying that single frame from the movie in the cinematography class has a better chance of success with the defense of fair use, as it can be argued that such did not diminish the value of the copyright. Of course, we have other elements in our favor, such as it was a small portion of the work as a whole, and it was used for educational purposes. Please note that in the examples I've just given you related to fair use, I'm trying to show two extremes. But as I mentioned before, fair use is determined on a case-by-case basis. And even the relatively benign uses I've mentioned might be failed to be judged fair use. One argument you will see on YouTube is, I made this song popular again, featuring it on my channel. The copyright owner / artist has made a boatload of money because of me. While I like this argument, and it's an incentive for the copyright owner not to take action against the YouTuber, it is not explicitly part of the fair use doctrine. I suppose you could argue that not only has it not diminished the value of the copyright, it has enhanced it. Unfortunately, that's not the only consideration for fair use to apply, as I previously discussed, and cases like this are best left to lawyers to figure out. So do you need a copyright? What I mean by this is, do you need to register your works with the U.S. Copyright Office? You should know that when you create an original work and affix it in a tangible form, it is protected. The issue here is burden of proof. Let me give you an example. Let's say you hear a song on the radio. The lyrics are identical to a song you wrote 4 years ago, and the melody sounds strikingly similar to yours. You think to yourself, this can't be a coincidence. You rummage through your song library and you find a scribbled set of lyrics for the song. Maybe you wrote chord names over the lyrics. You even find an old recording where you played guitar and sang it into your cell phone because you didn't have studio equipment. You transferred the song file to your computer for safekeeping. You listen to the recording and then go to the internet and listen to the song again that you heard on the radio. It's almost identical. You do a little research and you find that the publisher of the song is the same person you played your cell phone demo to 3 years ago. What do? Well, you probably hire an attorney. What do you think the first thing the attorney is going to ask you? That's right, for some cash. Next, she'll probably ask if you filed with the U.S. Copyright Office. Because if you did, it's probably a slam dunk. The attorney will ask you to send them a copy of your song file and the copy of the U.S. copyright registration. She'll listen to your song and the potentially infringing song. And if she thinks the songs are substantially similar, she'll contact the publisher and the record company. She'll also want to request a deposit copy of the song that you filed with the U.S. Copyright Office when you filed for your registration. What if you didn't file for a copyright with the U.S. Copyright Office? All is not lost, but the burden of proof is on you, and it can be challenging. Perhaps you can get metadata from the song file you recorded to show that the file was recorded 4 years ago. Unfortunately, that data can be changed and faked, so it's not especially convincing. You have your page of scribbled lyrics, and perhaps you wrote a date and maybe even a copyright notice on it. But the publisher will argue that you could have written that 5 minutes ago, along with a date that's 4 years old. I'm not trying to scare you, but filing with the U.S. Copyright Office is inexpensive insurance, and it will shift the burden of proof in your favor. I must add that the music industry has a very good ethical record with regards to purposeful infringement. A copyright is insurance, just in case. You may ask, how do I know if filing with the U.S. Copyright Office is right for me? Let's take a look at that. If you create works and you just don't care if someone uses your works or how they use them, then there may be no reason for you to file with the U.S. Copyright Office. Be sure about that. I can think of some scenarios where people could get very upset about how their music was being used. If you create works with the intent that they have some commercial viability, that is, you would like to be compensated in some way for creating them, then you should consider filing with the U.S. Copyright Office. Before I close, I want to mention a few things I strongly advise against. Don't seal a copy of your works in an envelope, mail it to yourself, and think you are protected. This is the same thing as 6-year-old Jeffy jumping off the garage roof because his friends told him he could use a golfing umbrella as a parachute. It's stupid. If that was a valid way to protect yourself, the U.S. Copyright Office would be out of business. In 2021, the U.S. Copyright Office made about $43 million in registration fees on a little over 400,000 registrations. Obviously, some folks think it has value. If you can't afford the registration fee, I understand. As I previously said, the industry has a good reputation when it comes to intellectual property rights. They absolutely count on strong intellectual property rights, such as copyright, to make their revenue and protect themselves. Next, don't get cute with the U.S. Copyright Office. Don't try to get creative to save money by stringing 50 cues together and try to pass them off as one cue so that you can register a total of 500 cues instead of just 10. I truly don't know what would happen if you tried to do this, but the U.S. government often takes a dim view of folks trying to perpetrate a fraud on them. It's probably a great way to have your copyright invalidated at a time when you desperately need it. Also, don't list your 2-year-old daughter as a co-author in an attempt to extend the copyright period way beyond your life plus 70 years, unless she substantially contributed to the work. It's probably another great way to get your copyright invalidated. In closing, I'll summarize that filing with the U.S. Copyright Office is relatively cheap insurance to protect your works and have proof of ownership. I register my compositions with the Copyright Office. What you do is up to you. As of 2023, you can copyright 10 original, unpublished music works yourself online for $85, or 20 performances for the same price. It goes up in price from time to time, and I believe when I first started copywriting songs decades ago, it was something like $20 or $30, and I had to request and fill out paper forms. Consider watching my episode where I take you through an actual online session of me registering 10 of my songs with the U.S. Copyright Office. Hopefully I haven't wasted your time. Take care, and I'll be back in another episode soon.